My name is Nick Guinn, and I'm an intellectual property attorney here in San Antonio, Texas. I would like to talk to you about the patent application process. In the United States, we have three types of applications available. First, we have plant patents, which are fairly uncommon and we're not going to worry about. We also have design and utility patents. Design patents protect the way something looks. Take this chair, for example. I've never seen the chair that looks quite like it. And when this chair was designed, a design patent may have been appropriate, even though technologically there's nothing particularly fancy or novel about this chair. Utility patents, on the other hand, are probably what you and I think about intuitively when we think of patents. There's a problem, and you've identified a solution, maybe the combination of X, Y, and Z. To start the process, we visit and discuss your invention. Optionally, we can conduct a patentability search. Now, I like to work with an outside search firm made up of former patent examiners. They're great because they're far more efficient performing a search than me, and they're going to look for prior art references much in the same way that the patent examiner would. I think this is great, and it will help drive how we draft your patent application. Why waste time on things that we're never going to get allowed or approved? Once we're ready to move forward with the application, I will meet with you and/or the inventors to really dig into what makes your invention special, and so that I can describe it adequately to the patent office. Because if I can't do that, then there's no patent. We'll also share your drawings and your prototype, if you have one, with a draftsman, and the draftsman will prepare formal patent drawings. We'll take this work product and prepare and submit your patent application. Nothing's going to happen for a while. In fact, 12 months after your application, you'll receive a notice of publication, which means the Patent Office has officially shared your application with the world. Another 6 months will pass before we actually get something really substantive, an office action, in which case the patent examiner will give us a thumbs down. Now, that doesn't mean that I've messed up your application or that we've done something wrong. It simply means that we're drafting your application broadly and trying to get you the broadest rights possible. In fact, getting a thumbs up from the beginning isn't necessarily a great thing in a patent application. An examiner can reject your application for really one of four reasons. Under Section 101, the examiner can find that your application is for non-patentable subject matter. This requirement means that you have not identified a process, a chemical composition, a machine, or an article of manufacture, but instead, maybe you've filed an application for an abstract idea, a law of nature, or a naturally occurring phenomenon. An examiner can also reject your application under Section 112, enablement. To satisfy this requirement, we need to provide sufficient information that someone of ordinary skill in the art could make and use your invention. Probably the two most common grounds for rejection are 102 and 103. These are the rejections that are based on prior art. An examiner will perform a search of existing technology, applications, patents, commercialized products to see, is what you're claiming in your application already in existence? If an examiner can find a single reference that checks all the boxes, then your application or your claim is rejected under Section 102, anticipation. If an examiner needs multiple references and can piecemeal together the different elements of your invention, then your claim is rejected under Section 103, obviousness. If you receive an office action rejecting one or more of your claims, we have an opportunity to pursue the 3 A's. Amend, argue, or abandon. And we can perform a combination of these. And it's through this back and forth with the Patent Office that we hopefully obtain a notice of allowance. If you obtain a notice of allowance, you can accept, pay a fee, and get a patent. You can keep fighting, or you can file an application, and of course you can do a combination of the three. Once you pay the issuance fee and you get a patent, great, you've come a long way, and your patent's going to last 15 years in the case of a design patent, or 20 years in the case of a utility patent. The requirement for a utility patent, of course, is that you pay maintenance fees at years 3, 7, and 11. Congratulations. I hope you enjoyed this video. If so, and you'd like to learn more about patents, I encourage you to check out the website, nickguinn.com. I look forward to knowing you, and until then, take care.